You found my name in the rain on the porch. I kept it small like a pin in a glove. Your shadow leaned on the apple crate step, and the clock in the hall would not answer us. Stay a little while, stay a little near. Your breath on my cheek like a borrowed fear. Dance me slow, paper moon lace. Hold my hand in a stranger place. Hold my hand, sweet and still we could disappear. Dance me slow and leave me here. Your collar was white, but your eyes were bold, like a key in a jar with a secret hold. I heard the boards count softly our feet, and the room grew thin as a candle leaf. Stay a little while, stay a little near. Your breath on my cheek like a borrowed fear. Dance me slow, paper moon lace. Hold my hand in a stranger place. Hold my hand, sweet and still we could disappear. Dance me slow and leave me here.
Oh, good morning, everyone. How are you guys? I hope everybody is doing well. Hope you guys had a great Memorial Day weekend. And there you go. That is the new, quicker, shorter summer intro. So now that I know how to do the whole 3D camera thing, it'll still be the same length. I'm just going to add more scenes, but probably not for a while. I got other stuff I need to do. All right. So this morning, Carly Gregg. She has filed an appeal. The Mississippi Supreme Court is hearing it, and basically, they're saying that the argument is that her original trial was not fair. The sentence didn't match her age, and also that her they didn't take into account the impact and effect that the medication she was prescribed and taking had on her. So that is their arguments. She was convicted of attempted murder and first-degree murder. She shot her mother multiple times and killed her. And then an hour later, when her stepfather got home, she shot him in the shoulder. So I just thought, because we've been talking so much about appeals, that it would be a really good idea for us to watch how an appeal goes, and really how they work, and what the arguments are, and what's allowed, what's not allowed. So I'm gonna start it now. We're a little behind, but just in case they take a break or whatever, we'll be able to skip through that. All right. So I'm so glad that everybody's here. I've missed you all. I'm so glad to be back tomorrow. I really, really, really want to go through Austin Drummond's hearing. And we also still need to listen to Suzanne Miracle's sentencing. So you guys tell me what order you would like to do that in. Would you like to do Suzanne's sentencing first and then Drummond, or you tell me, and that's how we'll do it. Welcome into everybody who's new, first time. Grateful, good to see you. Rye, first time here. Thank you for being here. Karen, Mr. Shine, Kimberly, Chicken Lady, Holly J, Shamina. Great to see all of you guys. All right, here we go. Make sure it's loud. All right, there we go.
You see that?
I'm going to put it right in the middle.
Mr. Clerk, would you sound the docket, please?
2024 KA 1178 SCT Carly Madison Gregg versus the State of Mississippi.
What says the appellant? What says the state?
The state's ready to proceed, Your Honor.
Okay. Oops. Murphy, we'll hear from you.
Good morning. Justices, may it please the court.
Also, I forgot a very important detail. The attorneys that are representing her now are not the attorneys that were representing her at trial. There was some kind of issue, and yeah, so she's got new attorneys. Hey, Daria. Hey, Jenny. Good to see you. Grateful says, this case has fascinated me for however long it's been. What, a year now? I felt really bad for that young girl, even though what she did was awful. Something hasn't sat right with me and this case. Well, I find cases like this fascinating as well. First of all, I'm always interested in the appeals process, but also it brings to the forefront a much larger and really important question. How do we, as a society, determine which youthful offenders, children under 18, are irredeemable and must be sentenced, as she was, with life without the possibility of parole, and which ones are redeemable? How do we make that determination? Because if we learned anything, we learned a lot of things, but one thing we learned for sure from the Athena Strand murder trial, I refuse to say his name, is that there is no real certain way of knowing and predicting how human beings are going to act in the future. People are going to people, and there's no, yes, past behavior can be a good predictor of future behavior, but people can and do change, especially children. When their, frontal lobes are all done developing and all of the things. And she might be. And Jonah's mom says, I'm sorry, I do not feel sorry for her. I'm not saying that she's irredeemable, but she at this moment is a monster, in my opinion. Yeah, I mean, the crime she committed was heinous, but I'm curious to the arguments, and let's see how this goes. All right, here we go. Also, there's trials coming up in June that I want to cover. I'm really trying not to cover that. I kind of want to, because it's an interesting trial. The case is just horrendous. Josie Dykeman, the trial itself was really interesting. It's just the case is horrendous. And we just have done so many kids' cases. You know what I mean? It's just like it's never ending. I don't understand that at all. All right, here we go.
My name is James Murphy, and it is my honor and it is my privilege to be here on behalf of Carly Madison Gregg. Here at co-counsel table with me is Lance Mixon, and we're both honored to be here as appellate counsel for Ms. Gregg. Now, this case is ultimately about whether a 14-year-old child received the fundamentally fair process the Constitution of the United States and the Constitution of the state of Mississippi requires before a juvenile can be sentenced to the most severe punishment, given the harshest sentence that the state of Mississippi can impose on a juvenile, and that is life without the possibility of parole.
Counselor, let me stop you there. I've read the sentencing order. The
Yes.
sentencing order in this case says that she's been sentenced to life imprisonment, which under the statute, and I think this is consistent with the argument you make on the sentencing issue, The statute, in subsection 2 of the sentencing statute for first-degree murder, gives two options. The jury can do life, can give life imprisonment, and if the jury doesn't, then the judge can assign a term of years. I don't know that I agree with you that this is a life without the possibility of parole sentence. The sentencing statute in subsection 3 seems to say there's life imprisonment. It doesn't seem to say, it does say there's life imprisonment, and then there's life without the possibility of parole or a term of years. So I'm reading this sentencing order, and to me, it's life imprisonment, not life without the possibility of parole. So why do you take the position that the sentencing order, what the sentencing order says is not what the sentence is?
Well, we would agree with Your Honor on that point, and if the state would concede that, I think we could make an easy argument of our sentencing argument here today. But I think the state's position is going to be that life sentence that was imposed by virtue of the parole statute imposes life without the possibility of parole. The jury in this case was given a sentencing instruction that gave them the option of sentencing Carly to life imprisonment or life with the possibility of parole. Now, by virtue of those two options, if they're not giving her life with the possibility of parole, by giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
Well, I understand there's a separate parole statute in play here, and I can't remember the style of the case, but I know this court's issued an opinion that addresses the interplay between that parole statute and life sentences in other contexts. But just strictly speaking, or leaving the application of the parole statute out for a second, there are two options in that sentencing statute: life imprisonment and a term of years, and this sentencing order says a life imprisonment. So I don't see an inconsistency between the sentencing order or the legal sentences under the statute. And since that statute doesn't mention life without the possibility of parole as a legal sentence for this crime, I'm right where I am. I'm struggling to see why this is being interpreted as a life, other than the jury instruction, which admittedly doesn't match the sentence. But what we have in front of us, which is the order of the court sentencing Ms. Gregg, this is a life imprisonment sentence, which is consistent with the statute and doesn't seem to be without the possibility of parole.
And we would, yes, Your Honor, we would agree with Your Honor's interpretation of that. And again, if the state would concede that, we would certainly move on from that argument, but the state has argued in their response to our brief that by virtue of the parole statute, that life imprisonment judgment is in effect a life without the possibility of parole. And as I'm sure Your Honor and the court is aware, the legislature amended the first-degree murder sentencing statute 97-321, amended that statute effective July 1st, 2024, and added a juvenile-specific sentencing structure for both first-degree murder and capital murder. And subsection 2C, which deals with capital murder for juvenile convicted of capital murder after July 1st, 2024, it gives the jury two options, as I think Your Honor would concede. It gives the jury the option of sentencing a convicted juvenile to either life imprisonment or life without the possibility of parole. However, subsection 2B omits that option and only gives the jury the one option of life imprisonment. And I think that goes along with what Your Honor is saying. The first-degree murder sentencing options for a jury in a juvenile case only gives the jury the option of sentencing a juvenile to life. And by virtue of the legislature defining life without, or including life without parole in subsection 2C, and not defining life as life with parole, the only other option is that life imprisonment means life with the possibility of parole. So we would concede, Your Honor, that is the case. In fact, if the court interprets the amendments that way, we would concede that argument. But from March 19th, 2024, when the incident occurred, until the verdict and sentencing order were rendered on September 20th of 2024, this entire case, the entire case, from investigation to indictment to psychiatric litigation to motions filed to motions argued to expert evaluations to discovery to trial to sentencing, It proceeded in approximately 6 months, 183 days to be precise. In a medically and psychotropic medication evidence and dissociation case of this nature, that pace was extraordinary. And the accelerated pace of the proceedings affected virtually every aspect and major issue now before this court. And my first issue I was going to begin with was the sentencing issue, but as the court, I think we've discussed that. If there are any additional questions about that, we would argue certainly that the amended statute does not give a jury the option of sentencing a juvenile convicted of first-degree murder after July 1st, 2024. We would argue that the new amendments do not give a jury the option of sentencing, nor does a judge have the option of sentencing a juvenile convicted of first-degree murder, does not give them the option of sentencing her to life without parole. Now I will transition to the Miller issues. Again, we would argue that the new amendments, they pretty much make Miller obsolete in the context of sentencing a juvenile after the amendments. But assuming that the Miller progeny of cases is still in effect and is still the controlling law when it comes to determining what's proper sentence for a juvenile convicted of first-degree murder, we would propose that the Miller framework was not met in this case. The Miller requires individualized sentencing before a child may be condemned to die in prison. And again, we're operating under the assumption that the state's position is that Carly Gregg was sentenced to life without the possibility of parole. The proceedings here never became the careful, individualized juvenile sentencing hearing contemplated by Miller. The sentencing phase of this case, and again, this case went from the occurrence of the event on March 19, 2024 to the trial on September 16th, concluding on September the 20th of 2024. The sentencing phase, and I'm going to use that term loosely, the sentencing phase of this case consisted of the court announcing the verdict of the jury and then transitioning immediately to asking the state whether they wanted to call their first sentencing witness, to which the state responded that they basically wanted to rest on the evidence that had been previously presented and proceed with argument only. And the defense did the same thing. The defense elected to rest on the evidence that had been previously presented and proceed with argument only. Now, we would argue that this immediate pivot from the announcement of the verdict to the sentencing phase was wholly inadequate in light of Miller. There was no meaningful mitigation development process. There was no opportunity given to the defense to marshal mitigation witnesses. They were given no opportunity to call witnesses, family members, teachers, and as a matter of fact, as part of the pretrial process, the defense listed as one of the potential witnesses the grandmother of Carly Gregg, Miss Vicki Breland, who also happened to be the mother of one of the victims, Ashley Smylie. She was listed as a potential witness, and she was not allowed to testify at the trial. So it stands to reason if she was not allowed to testify at trial, then the question then becomes, would she have been allowed to testify during the sentencing phase? And again, I use that term loosely because there was no meaningful opportunity to conduct a Miller-compliant sentencing hearing. There was no PSI, pre-sentencing investigation conducted, no report. The jury was exposed to confusing and inconsistent parole rhetoric by the prosecution at one point. And again, I'm going back to the sentencing hearing, which consisted of, and it's confusing, the record is confusing as to whether each side was given 7.5 minutes, 15 minutes total for their sentencing argument, or whether they were each given 15 minutes. At one point, it looks like the judge gave one side 7.5 minutes, and then the other side was given 15 minutes. So it's not clear to me from the record whether they were given 7.5 minutes to argue the sentencing phase or 15 minutes to argue the sentencing phase. But at one point during the state's argument during the sentencing phase, the state told the jury that if you give her, and again, this is going to the sentencing instruction that they were given the option of life or life with the possibility of parole. The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, we don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence. But she may be out in as little as a year. And again, I'm paraphrasing, but you may see her at the supermarket, or you may see her at church. You may run into her at any place outside in public. And again, we would argue, and we argued in our brief, that that is improper golden rule rhetoric. It's appealing to the fears of the community, and that is improper. And I understand the state's going to argue, and has argued in their brief, that the defense failed to object to this, but notwithstanding that failure, we would ask this court to analyze that under the plain error doctrine and or pursuant to the ineffective assistance of counsel claims that we've made in our brief.
So they've raised ineffective assistance of counsels. I can't even talk. I don't even know why I'm live if I can't speak. Lord. They've raised ineffective assistance of counsel claims. I've told you guys this before. Now, I just want you guys to know we're not going to hear a decision today. They're gonna hear the arguments. As you see, each side gets 20 minutes. We're going to hear their arguments, and then the justices are going to go back because they have to look at not just the claims, the arguments that they're raising, that well, in this case, they would be the petitioner because they're the appellate. So the burden falls all solely on them. The state has done their job. They don't have to prove anything at this point. The defense has to prove everything. But they're going to, listen and then also read the state's response to the filings. But they're also going to go back and look at the actual trial proceedings and what took place there. And I will agree that there does seem to be quite a bit of confusion respective to her sentence, because as I wrote, based on my research, she received life without the possibility of parole. But it seems like now maybe she didn't. So it's if the defense attorney, if the appellate attorney is saying, yeah, Your Honor, that is what the statute says, and and it is what the sentencing order says, but yet there's some sort of, but the state is not conceding that, has not conceded that. So it'll be interesting to see where this goes moving forward. But I do think it's interesting that they've raised an ineffective assistance of counsel claim. And I will tell you, those claims are the burden of proof for those claims. The bar is very, very high.
We can see no strategic reason why a competent defense counsel would not object to that type of rhetoric argued in a sentencing phase. And in addition, even taking into consideration if the Miller progeny of cases is still the law and still applicable to juvenile first-degree murder and capital murder cases, the record is replete with examples of why there were mitigating factors. And we would submit that the juries, and again, assuming they elected to sentence her to life without parole. And by the way, let me back up, I digress just a little bit. After the prosecution's statements about parole eligibility and when she might be out within a year, and you might run into her at the supermarket, after the jury began their deliberations, almost immediately after they began their deliberations, we know that parole was on their mind and how long she's going to spend in jail if she gets granted parole eligibility, because they submitted a question, and I'm going to paraphrase this too. If Carly is granted parole eligibility, if she's given life with the possibility of parole, which is one of the two options she was given by the court, if she's given life with the possibility of parole, how long will she serve years-wise? So we know that was on their mind. We absolutely know that was a question that they had in their mind going into deliberations. Nothing minimizes the horror of what happened to Ashley Smylie or the trauma suffered by Heath Smylie. Nothing minimizes that. But Miller requires courts to distinguish between irreparable corruption, incorrigible youth, and transient immaturity before condemning a child to die in prison. And again, assuming that the state's position is correct, that she was sentenced to life without possibility of parole, that is exactly what she was done. She was sentenced to die in prison, because if she's not eligible for parole at any point, then she will pass away in prison, and that's in effect a death sentence. And I want to read
Mr. Murphy,
from a brief.
Mr. Murphy,
Yes,
let me
Your
just interrupt you there for a second. I want to clarify something for purposes of I know this court has written that for purposes of the application of that parole statute, the one that forbids parole for people guilty of first-degree murder, we have held in the Miller context that is the same as a life imprisonment. So, but you've still got, I think you conceded, not just as to those comments that were made by the prosecutor, but also as to the hearing itself and the brevity of the hearing, et cetera. There were no objections made by defense counsel that would have preserved that issue for appeal, were there?
No, Your Honor, there were no objections. And as to that issue, Your Honor, a case that we cited in our brief, Presley v. State, which is 474 Southern 2nd 612, a case that was decided by this court in 1985, a case where the sentence was vacated, and in that case, a pre-sentence investigation report had been prepared and submitted to the court. The trial court offered defense counsel, the same as apparently the trial court did in this case, gave defense counsel the opportunity to present mitigation, and defense counsel nevertheless failed to meaningfully develop mitigation evidence. And the court, in that case, vacated that sentence based on the rationale and the holding that, and I'm going to quote from the Presley court, "We recognize that there are cases, even where the appellant and his attorney fail to prepare and complete a sentencing record, as was done in this case, or not done, as the case may be, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed." So we would submit to Your Honors that this court has the power to impose that duty on the trial court, just as it would impose the duty on the defense counsel. And even barring that plain error submission that we are offering here today to give the court the authority to review that, again, I think we've offered the Strickland v. Washington ineffective assistance of counsel claim. We can fathom no strategic reason why defense counsel would not want to ask for time.
Is this court in a position?
Okay, that's important right there. One of the, as I understand it, and for anybody who's new, I am not an attorney. I didn't go to law school. I have no law degree. I've never worked in the law field at all. There's my disclaimer. Okay, I'm not offering legal advice. If you get into trouble and you need a lawyer, do not call me. Call an actual attorney. First, remain silent, then call an attorney. All right. Anyway, I find this interesting because one of the elements of ineffective assistance of counsel is that we've talked many times, right, about trial strategy on the part of the prosecutor and the part of the defense. And for example, we were all baffled when Corey Richins' defense, after acting like they were going to put on this case and it was going to just, blow our socks off, right? That then they just rested. That is a trial strategy. However, during the sentencing phase, as ridiculous as it was, they did present what they determined to be mitigating factors. It was preposterous. But nevertheless, the argument over what is trial strategy and what then becomes ineffective assistance of counsel is very, very gray. And it's, it's very, it's difficult, but I would think that just going based on what I've my life experience watching all of these trials, covering all of these trials, learning about the appeals process, I would say that not putting is particularly for a 14-year-old kid, and make no mistake, a 14-year-old is a kid. Did she do something very grown up? Yes, she did. She took a life intentionally, purposefully. But she's still 14. And so not even attempting any mitigating circumstances or mitigating evidence to present, I think, goes beyond trial strategy. And Justified, thank you for becoming a member again, babe. I appreciate it. Welcome to the ward. I got some stuff I'm working on for y'all too, for whenever you, become members and stuff like that. So yeah. Jonah's mom, hi, Jonah's mom. And Jonah says, I've watched the whole trial, and I honestly do think that she has a case for ineffective assistance of counsel. I have to say that not presenting mitigating evidence and going directly from a guilty verdict to sentencing is a problem. Like, even if because it was done by a jury, right, then they should have prepared for that. If they were going to move that quickly, then they should have had, while they were preparing for trial, they should also be preparing in case she's found guilty and they need to present mitigating circumstances. That's important.
On this record, to evaluate the prejudice prong of Strickland, not knowing what mitigation evidence might have been discovered had that work been allowed to proceed?
I believe that we could evaluate the prejudice prong based on what we know about what had been presented earlier in the case. We had two forensic psychiatrists who testified in this case. And I believe even the state's forensic psychiatrist opined that Carly was not a psychopath, that she was not evil, and that she came close, and I'm paraphrasing here, that she came close to the evaluation needed to reach the McNaughton standard. Even the state's own psychiatrist stated as such. And then you had the defense psychiatrist who found that she did meet the McNaughton standard. So the failure of the defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up earlier, the witnesses, the lay witnesses that could have been marshaled and provided, the family members that I believe are here today and that were prepared to testify on behalf of Carly in the sentencing phase, teachers, friends, all of those things, as far as we are aware and as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf. So yes, Your Honor, we would submit that the record is sufficient to evaluate the prejudice prong of the Strickland analysis. Now, outside of the sentencing issues that we've discussed, Your Honor, the trial court announced at the very first interaction between the trial court and the litigants in this case, announced not once, but twice, that this court does not continue cases. And it even mentioned that y'all have heard me say this before today, that this court does not continue cases. Now, that posture shaped the atmosphere of the litigation from the very beginning. Now, you may ask, is that in and of itself, is that an abuse of discretion? And we would offer, and we cited Leonard v. Leonard, where a discussion was had of whether a court can issue blanket denials of continuances, and that court held that it is abuse of discretion to prejudge and pre-rule that there are no continuances allowed under any circumstances. And that we would submit that is exactly what the trial court did in this case, announced from the outset that there are no continuances going to be granted. Now, the state offered in their response brief that this was not a blanket denial of continuances. This was just an attempt by the trial court to prevent dilatory tactics of the litigants. But, Your Honor, looking at the four corners of the transcripts, we saw no caveats issued. There were no continuances unless so-and-so happens. No continuances unless there's a darn good reason. There was none of that. It was a blanket denial of continuances. Well, then the state's going to submit to the court. Well, the defense never asked for a continuance. So there's no harm, no foul. It's harmless error. Even if it's error for the court to issue a blanket denial of continuances, that error is harmless. But to that, Your Honor, we would offer a plethora of cases, including Mississippi Rule of Evidence 103C, that says no further objection or offer of proof is required where the court's ruling is definitive. Smith v. State, which we cited, 724 Southern 2nd 280, preservation rules do not require actions that would serve no practical purpose.
Mr. Murphy, without any motion being filed, exactly what do we have in the record where we could say that it was an abuse of discretion not to grant a motion for continuance?
Well, it was not necessarily an abuse of discretion to not grant a motion for continuance because obviously, as we would concede, there were no motions for continuance.
But
But
I
there
mean,
was-
are there any reasons for a continuance? I haven't even heard you argue whether there were any reasons for a continuance that were considered, contemplated, and not requested. You're just simply asking, as a statement of law, for us to find the trial judge in error because he made a statement.
Well, Your Honor, and again, going back to this line of cases that basically says a litigant, a defense attorney, or any attorney is not required to ask for something he knows he's not going to get in order to preserve error. That's exactly what Mississippi Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Counselor, further objection seems to indicate that there was an objection initially. So I think those cases that you're citing, in those cases and the text of that rule, still seem to require an initial objection or motion that is denied. I know that Leonard versus Leonard, there was a motion that was denied. That's what the court was reviewing for error, was the decision. So, I mean.
And I think the rules of civil, at least the rules of civil procedure, required that any request made to the court be made by motion, written motion before trial or during trial, and oral motion. And so even, I hear your argument, but I don't hear you saying any reason why this was error.
Well, Your Honor, it was error because it number one, it chilled the litigants. They I hate to say afraid perhaps, but, and going back to Smith.
All right. So what he's saying, I think, basically is that the defense needed more time, but because the judge had made a statement about continuances, they felt their hands were tied and could not, they weren't going to waste any time filing a motion they knew they weren't going to be granted because unlike James Owens Esquire, who read all of the things from Judge Cranick, and Judge Cranick very clearly said that a motion for continuance will not be granted based on Sarah Boone, whether she retains an attorney or not, needing time to prepare for the case. That's not going to be a reason why a motion for continuance would be granted. That's, so that's what the judge is saying. Yeah, but him saying that, I mean, they could have still made a motion and they didn't. So how is that the judge's fault? How can the judge be in error in making a ruling when there was no motion filed for the judge to rule on in the first place? Like, you're putting the cart before the horse, which is backwards.
Versus state.
I'm not sure anybody was chilled in this case. Just reading the transcript, it seems to me that there was very active participation in this case by the lawyers. And certainly there's no reason a motion couldn't have been made, but I'm just wondering, give me some basis for the continuance.
Well, Your Honor, and this is getting into the the orders for psychiatric evaluations, which we think were premature and beyond the scopes of Mississippi Rules of Criminal Procedure. The litigants, they were very active, Your Honor. It appears that they were bending over backwards to abide by the court's, for lack of, and I put it in my brief, so I'm going to say it here today, rocket docket. Announced that this trial is set for trial September 16th, and there's absolutely no reason that we see that this trial can't go forward. So everybody was bending over backwards to accommodate that trial schedule.
As they should, though, isn't it? I mean, that's what we want, is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work. And there's no basis in the record to say a continuance should have been granted.
Well, it was continuing in a speedy fashion at the expense of Carly's constitutional rights. The trial court ordered her to undergo competency and insanity at the time of offense evaluations before the 17.4 threshold of announcing the insanity defense had been met. And that is simply not what the rules contemplate. And in fact, the defense attorneys in this case filed a petition for interlocutory appeal to appeal that ruling. Her constitutional rights were we would submit, trampled on because they were ordered to turn over privileged information, medical records that they would not have otherwise have had to turn over to the state, but for the insanity defense, which at the time they were ordered to be turned over, had not been properly put before the court. Sure, the defense counsel at one point said that we intend to assert an insanity defense, but with all due respect to all of the attorneys that were involved in this case and even the trial court, none of us are psychiatric or forensic psychiatrists. And so for me, as a defense attorney, to announce at the beginning of a case before my client has even been evaluated by a forensic psychiatrist, and for me as a defense attorney to say we're going to assert the insanity defense, I believe is malpractice. Because I don't know what an evaluator is going to say once that evaluator reviews all the records and interviews Carly and makes a determination as to whether she has met the Minalton standard. So they were given a Hobson's choice to either turn over those records and waive the privileges that go along with turning over those records.
This is interesting to me because she's 14. And I wanted to bring this up earlier, and I just I was late, and I apologize. I have the Nuggie today, so I had to get her situated first. But she was charged and tried as an adult at 14 in Mississippi, whereas Mackenzie Shirella, who's all over the news again right now, was charged in juvenile court. And the proceedings the way that juvenile court is handled is very, very different than the way that adult criminal trial is handled. And I would submit that one of the fundamental issues and questions in the legal community is part of being declared competent for trial is the defendant's ability to assist in their own defense. And how can a 14-year-old truly assist in their own defense? How can they tell a team of lawyers who to contact, what they should be looking at? Do you know what I mean? I don't think that she is, I don't think that Carly was insane. I will say that. I will agree with that. And I will say that she definitely 1,011 billion% needs to be punished for what she did. But I will also say that one of the rights afforded every American under the Constitution is the right to a fair trial. And the question and a what's the word that I can't think of? It's on the tip of my tongue. A vigorous defense. Did she get that?
Or waive the defense altogether, and they chose to preserve that defense. And until and unless they file the 17.4 notice of insanity defense, the court does not have the power. The court does not have the power to order Carly to undergo psychiatric evaluations at the behest of the state. The court.
Does that apply? Okay, so the state made a motion, as I recall. Correct me if I'm wrong on this, because there's a lot going on in this record.
Yes, Your Honor.
And the court granted the state's motion and sent Ms. Gregg for evaluation, both as to competence to stand trial and the McNaughton issue.
Correct, Your Honor.
I misspoke. Mackenzie Schroeder was tried as an adult. There was some, when I looked it up, because I was confused why her trial was not straight. And there was that it was said that she was tried in juvenile court when I Googled it, which is weird. But so I apologize for that. I misspoke, and I'm sorry. She was tried as an adult. But I am curious about how the court determines which cases of juveniles are tried as adults and which are tried as in juvenile court. Because I think that a fundamental part of a defendant is being able to aid in your own defense. And I'm not sure that a 14-year-old is competent to do that.
But the psychiatrist, counselor, I don't remember which, to whom the court sent Ms. Gregg.
Thank you, guys, for clearing it up for me. She started out in juvenile court, and then they determined that she's going to criminal court. And she had a bench trial, which is interesting to me. Which I will say this. On the part of her defense attorney to opt for a bench trial, I think was likely a very smart move. Because it's harder to appeal to a judge's emotions. Certainly they feel emotions, and certainly they are always empathetic and sympathetic to the victim and the victim's families, always. However, they are bound by the law, and so they make their ruling on the law. So if you're going for, if you have a highly emotionally charged case, which hers is still, it's better to go by, and they are decided by the level of the felony offense. I understand, like, I get that, but not. Let's just listen to this, and I will, because I need to think about how I want to say this, because I want to make sure that I'm conveying my thoughts correctly.
For that evaluation, reached an opinion as to competency to stand trial, but declined to issue an opinion on McNaughton. Is that correct?
The initial state's expert, yes, that is correct.
All right. Does the fact that that expert declined to address McNaughton or issue an opinion on that affect your argument that it was wrong to send her for that
well, the
evaluation?
Only reason she declined to render an opinion was because there were some issues with marijuana or some other.
Whatever the reasons were,
right.
Does that affect your argument that it was incorrect for the trial judge to order?
It absolutely does not affect my argument. That was premature, and that was incorrect and outside the court's power to order that exam at that point in time.
And you're saying that the harm that resulted from that is that it gave the defense's strategy up too soon and forced the defense to disclose documents that wouldn't have otherwise yet disclosed?
Among other things, yes.
But those documents would have been disclosed because the defense did pursue the insanity defense.
Yes, Your Honor. If the defense had ultimately chose to pursue the defense of insanity, those documents would have been produced. But if the rules had worked the way they're supposed to have, and the timing had worked the way the rules require, then the defense would have had Carly evaluated by their expert, who would have reviewed all those records and interviewed Carly and made a determination, yes, she qualifies for the McNaughton insanity defense, then you hand it all over. But if that, in contrast, if that evaluator and that expert had said, no, she does not qualify, then the state does not get the benefit of those privileged documents. The state does not get to have their expert evaluate her. So by jumping ahead and then ordering that the state gets to evaluate her ahead of time, it inverts the whole process. It gives the state access to documents that they may not have otherwise had access to. And with those privileged documents, of course, come waivers of communications that Carly had with her treating physicians and psychiatrists and counselors, among other things. And I think everyone would recognize, I think that we'd ask the court to take judicial notice that each evaluation of somebody would affect the next evaluation. And by virtue of the state having the first, I believe the state had the first opportunity to evaluate Carly, because the defense's first expert was taking more time to evaluate her than was initially anticipated. And going back to that, they certainly weren't outside of their time limit. According to Rule 17.4, the defense has until the time for filing pretrial motions to assert the insanity defense. And in this case, the court's pretrial motions deadline was August 30th of 2024. The court started pressuring the reports back in June or July of that summer, well before the pretrial motions deadline of August 30th. So the court entered the order July 3rd that she submit to a state expert evaluation.
Okay, Mr. Murphy. Are there any other questions of Mr. Murphy at this time? Okay. All right, thank you, Mr. Murphy.
Thank you.
Okay. Ms. Hartman, the court will hear from you at this time. Mr. Murphy took an additional 9 minutes on his primary presentation, so if need be, the court will also extend additional time to you.
Thank you, Your Honor.
This is an interesting question and one I've pondered myself. Justified says, I wonder how much AI will be helping to so thoroughly evaluate court transcripts for anything an appellate attorney can use. I'm curious about that as well. I mean, there is a level of, I mean, you can use, when you, like, they come in like a PDF, right? So you can use Control F and find, say, you want to look up every time an objection was raised and how it was ruled, what the objection was and how it was ruled, right? Then you could use the word objection, obviously. And so, but I am curious about this. I am curious if AI will become something that attorneys use to at least parse down the volume of a court transcript to start narrowing in on potential appellate issues. All right, so let's hear from the state.
Good
What's
morning.
the
My
state
name
say?
is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court. Gregg raised several issues related to both the guilt and penalty phases of her trial. Most of those claims are waived because she failed to contemporaneously object or otherwise raise those issues in the trial court. But even if we set the waiver bar aside, all of her claims lack merit and should be denied. I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow. It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing
I
statute.
understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to.
So
And the sentencing statute in this case allows for 2 sentences: life in prison if that's set by the jury, and a term of years. All right, so the sentencing the sentencing order in this case sentences her to life imprisonment. So absent the application of a parole statute, which itself could be amended by the legislature any minute, I don't understand. I get why you say the effect of her sentence is life without the possibility of parole, and I think that's relevant to the Miller discussion. But to the illegal sentence and the jury instruction issue, I think it's relevant what that sentencing order says. So what the sentence, you will agree with me, the sentencing order says life imprisonment.
Yes, Your Honor, it
And you will
does.
agree with me that that is one of the legal sentences under the sentencing statute.
Yes, Your Honor. So the legal sentence under the statute, the amended statute, like you mentioned, is life imprisonment.
And if the legislature were to amend the parole statute in this next session, I don't have any reason that they would, but if they did, and they were to remove the language that says you're no longer eligible for, the language that says you're not eligible for parole if you're convicted of first-degree murder, that's what relevates this effectively to a life sentence we've held, then all of a sudden she's no longer sentenced to life without possibility of parole. Is that correct?
I think, yes, Your Honor, because that's what the court did in Johnson versus State. That was this court. Johnson was originally convicted in 2000, which was pre-Miller, and he was sentenced to life without the possibility of parole, which was under the essentially mandatory life imprisonment without parole sentence pre-Miller. And he successfully filed for PCR, and he received a resentencing hearing in the trial court, and the trial court conducted the Miller hearing, considered the Miller factors, and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute or what the life imprisonment sentence actually is. And that when you consider those 2 statutes in tandem, essentially under the amended sentencing statute, life imprisonment is life without the possibility of parole.
Okay, so this is why there's an argument, all right? So what I Googled, because I already know the answer to this, but I wanted to see what comes up. Can a minor tried as an adult be sentenced to life without the possibility of parole in Mississippi? Yes, a minor tried as an adult can be sentenced to life without the possibility of parole in Mississippi. However, this penalty is only constitutional for homicide offenses, as life without the possibility of parole sentences for juveniles who did not commit homicide are banned nationwide. Homicide discretion, and here's where it's kind of where the hiccup is. Homicide discretion for juveniles convicted of murder or capital murder as adults, judges or juries have the discretion to impose this is such bad syntax, to impose an life without parole sentence, well, LWOP, so I guess if I read it like that, it's better, sentence, provided the sentence is not mandatory. Youth matters. Under U.S. Supreme Court precedents, sentencers must take the offender's youth and its attendant characteristics, such as immaturity and family background, into consideration. No incorrigibility finding is required. The U.S. Supreme Court ruled, Jones versus Mississippi, that a judge does not need to make a formal, specific factual finding that a juvenile is permanently incorrigible before handing down an LWOP sentence. So is that confusing to y'all? Because it's confusing to me. Is the sentence mandatory or not. She was tried as an adult. She was convicted of first-degree murder. So if under the Mississippi sentencing statute, no person can be eligible for parole if they are convicted of first-degree murder. They cannot be considered for parole eligibility, right? So in essence, the sentencing guideline determines that due to her being convicted for the first-degree murder, it's very confusing. Are y'all confused? Let's hear her. Let's rewind her back just a little bit. All right. And hear what her response is.
Hearing considered the Miller factors and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute or what the life imprisonment sentence actually is. And that when you consider those two statutes in tandem, essentially, under the amended sentencing statute, life imprisonment is life without the possibility of parole. And I think that the court can just look to its own decision in Johnson versus State, which is really instructive on this issue because it's one of the only cases that actually interpret the amended sentencing statute that went into effect in July of 2024. And this court recognized there that you have to read the sentencing statute and the parole statute in tandem to give effect to what life imprisonment actually means.
Also, I would think that if the sentencing intended for her to have life with parole, with the possibility of parole after a certain amount of time, wouldn't that have been included in the sentencing language? Wouldn't, when someone is eligible for parole, and it is like, let's take Gypsy, for example, only because hers is super easy to figure out, right? Gypsy had a sentence. Well, she didn't really get life, but who else? Megan Boswell. Let's take her. That's a good one. Because did she get life with parole? Shit. Look, let me just say it like this. When there is parole eligibility included in the sentencing, it's intended to be included in the sentencing. It's written in plain language in the sentencing orders. For example, life imprisonment. And then the sentencing statute requires that the offender serve 35 years in prison before becoming eligible for parole. And because it did not include that in the sentencing order, then I have to agree with this, with the state here who's saying that it should be interpreted as life without the possibility of parole, life imprisonment, because when they intend for there to be an option for parole, that's included. We did not cover this case, Melissa. We were covering, I forget who we were covering at the same time, we were streaming instead.
Because as Your Honor mentioned, life imprisonment is the maximum penalty under the sentencing statute. And you have to look to parole eligibility statute to determine what life imprisonment actually means.
In Parker v. State, we held that there should be a determination when that parole statute is in play. It's awkwardly worded, I think, but we said, let me find it, whether or not the defendant should be sentenced to a term of life imprisonment with eligibility for parole, notwithstanding the parole statute. Was there any attempt to instruct the jury on that or to raise Parker before the trial court to try to get a determination that the life sentence should be, notwithstanding the parole statute?
I'm sorry, are you asking whether the trial court should have...
I'm asking whether or not there was an attempt made to follow Parker v. State in the trial court. If you're going to sentence Ms. Gregg to life without the possibility of parole and claim that it's because the parole statute forbids parole. In Parker, we said there needs to be a determination of whether or not that sentence should be life with the possibility of parole, notwithstanding the parole statute. I'm asking you if that procedure that was laid out in Parker was followed in this case.
It was, Your Honor. At the sentencing jury instructions conference, the court and the parties were discussing the sentencing instructions, and there the court was looking at the state's proposed instructions and the defense's proposed instructions. And the court and the parties both acknowledged that under Miller, under Miller there had to be a Miller compliant hearing, but also that under Mississippi's sentencing statute as amended, life imprisonment meant life without the possibility of parole. So all the parties recognized that under that first sentencing option in the instruction, life imprisonment was effectively a life without parole sentence.
That's effectively true, but that leads us back to the problem with the jury instruction, which is life without the possibility of parole is itself not a sentence, a legal sentence under the sentencing statute to apply to a juvenile for first-degree murder. It's not listed in statute, correct?
Yes, you're right. I mean, the plain language of the sentencing statute doesn't say life without the possibility of parole. It just says life imprisonment.
And so that jury instruction led the jury to believe, I mean, it just didn't follow the sentencing statute because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, a life sentence with the possibility of parole, but that's not what the statute provides. And the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means, under the statute, life with the possibility of parole. So
I would disagree with that reading of the statute because I think you still do have to read the statute with the parole statute in tandem. I know that you're hesitant to concede that point, and I understand, but this court has held time and time again that the parole statute and the sentencing statute have to be read in tandem.
okay, and I might disagree with that because, again, what happens, we've sentenced a few people in this state to life without the possibility of parole because of the parole statute. What happens to the legislature? The legislature has in the past, has reformed the parole procedures and the parole, what if the legislature changes that statute and removes that language and all of a sudden makes people who are guilty or found guilty of first-degree murder eligible for parole? Do we have to go back and re-sentence everybody that was sentenced to life without the possibility of parole because we read the sentencing statute in tandem with the parole statute?
No, I think Johnson, this court's decision in Johnson versus State indicates that it's the statute that's in play at the time of sentencing. Because even though Johnson was sentenced in 2000, he was
The
re-sentenced.
sentencing statute.
Yes.
The parole statute is not a sentencing statute. The parole statute is a prohibition on parole.
Right. But in Johnson, this court also considered the parole statute that was in effect at the time that Johnson was re-sentenced.
Is that the court rewriting a parole statute as a sentencing statute when the legislature clearly intended to govern parole?
I don't think so, Your Honor. I think it's just interpreting what life imprisonment within the sentencing statute actually means. Because in order to determine what life imprisonment means, again, you have to consider parole eligibility. And to do that, you have to look at the parole statute. So the only way to interpret life imprisonment is to look at the parole statute to determine whether or not there is parole eligibility under that statute.
So, Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree, Your Honor, that it's interesting that the capital murder provision and the first-degree murder provision are stated differently in the statute.
Do you think maybe that's because the legislature intended them to be handled differently in reality, in the world, in life, in court?
Possibly, Your Honor, but there is a distinct difference between capital murder and first-degree murder. We tend to look at capital murder as more severe, but first-degree murder requires deliberate design, intent, premeditation. Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
Why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole. But now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
No, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between the two provisions. And the capital murder portion of the sentencing statute also provides for the option of life with the possibility of parole, where the first-degree murder sentencing provision doesn't provide for the life with the possibility of parole. So I think there is an intentional difference there in creating an avenue for parole eligibility within the sentencing statute for capital murder.
But you're treating them the same. That's my point. Thank you.
Okay. Yes, but Your Honors, I think that if this court looks to Johnson versus State, it's very instructive on how this court should deal with this issue here today, because there, again, the court dealt with this exact sentencing statute and the parole statute. It read them in tandem, and this court said that under the sentencing statute, the language, life imprisonment, under subsection 2B, which is the subsection we're operating under, life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole. And that's how, in this case, we know that Carly Gregg's life imprisonment sentence is without parole, and it's not with the possibility of parole. And kind of going hand in hand with that, Carly Gregg's jury had the discretion to impose a life imprisonment sentence, or if it couldn't reach that, then let the judge decide the penalty. And that's consistent with the United States Supreme Court's holding in Miller, which required an individualized sentencing hearing, after which the jury or the sentencer considers the Miller factors before imposing a life in prison sentence. And neither the Supreme Court nor this court have ever laid out step by step exactly how a Miller hearing is supposed to be conducted. If you look to Montgomery versus Louisiana, for example, or Chandler versus State in this court, or McGilberry, the Supreme Court and this court both say that the defendant has to have an opportunity to present evidence to support the Miller factors, and that the jury or the sentencer, because it could be the trial court in certain circumstances, consider the youth and its attendant characteristics using the Miller factors. And that's what happened here. Gregg had the opportunity to present evidence on the Miller factors, and her defense trial strategy was to focus on allowing the judge to sentence her instead of the jury, because the sentencing authority of the judge was only 20 to 40 years. So I think her trial strategy was clear, to hope that the judge would sentence her and not the jury, so that she could get a lesser sentence. But the jury instruction, SS1, which is at the clerk's papers 1093 to 1094, it lays out the Miller standard clearly, and it says it instructs the jury what the Miller factors are, and it instructs the jury to consider those factors in determining whether or not it should sentence Gregg to life imprisonment. And that, in effect, was the Miller hearing. Just because Gregg now says that she wished she presented more evidence doesn't mean she didn't receive everything that she was entitled to under Miller, which was a separate individualized sentencing hearing, and the jury considered the Miller factors and exercised its discretion to impose life imprisonment instead of letting the judge decide her punishment. And I think, circling back a little bit, I think on the jury instruction issue, it's also crucial to recognize that Gregg not only didn't object to the state's proposed jury instruction, which is SS1, but she actually withdrew her own proposed instructions and acquiesced to the state's instructions. So I think that goes beyond waiver, and the fact that Gregg agreed to those sentencing instructions, and now she can't come back on appeal and claim that the trial court erred in giving those instructions because she agreed to them. As I mentioned, Gregg received everything she was entitled to under Miller. That individualized sentencing hearing, the jury considered the Miller factors, and the state presented sufficient evidence on each of the Miller factors to support the jury's verdict. It submitted evidence on her chronological age and how her maturity level, education level, ability to maintain relationships overcame her young age, which was 14. Her family and home environment. She had a tough upbringing in the beginning, but once she moved out from her biological dad's house, for all intents and purposes, she had a great home life. Her parents supported her hobbies. They took her to guitar lessons, karate. They supported her academic success, and most notably, when she expressed any issue with her mental health, they immediately took her to get psychiatric and therapeutic help. And then the other Miller factors, the circumstances of the homicide offense. Obviously, the jury here heard significant evidence about the horrific nature of the murder. It heard and saw photos where Gregg shot her mom 3 times, point blank range in the face. So obviously, that the circumstances of the homicide offense weighed in favor of the life imprisonment sentence. So this court should affirm her sentences because she had a Miller-compliant hearing, the jury instructions adequately tracked the statute, and the state submitted sufficient evidence to support the imposition of the life in prison sentence. And I also want to briefly touch on Gregg's claim regarding the prosecutorial misconduct.
Let me ask you to back up. Your comment about the jury instruction adequately tracked the statute, and I hate to keep coming back to this, but the statute, when you say the statute, the sentencing statute does not have an option for life without the possibility of parole.
Yes.
It does not have that possibility.
That's right.
So when we're in a situation because of a case from this court, the Johnson case, the cases where we've basically held that effectively every life sentence is without the possibility of parole, so we might as well go ahead and sentence them to that. But we're in a situation where we're trying to work with that precedent from this court can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute itself tracks the language or tracks the law. Doesn't that seem like a problem for you where we can't actually track the sentencing statute that the legislature chose, which, by the way, these amendments took place after Johnson. They took place after Miller.
Mm-hmm. Yes, Your Honor.
That doesn't seem like a problem to you that we have to actually not track the statute to track the statute?
Well, I think the sentencing instruction did track the statute and that it said life imprisonment was the option, not life without the possibility of parole. So it didn't actually, the sentencing instructions didn't actually say life without the possibility of parole. It just said life imprisonment, and that's what the jury sentenced Gregg to. Then we know that's without parole because, again, going back to the parole statute, which says that first-degree murder is not a parole-eligible conviction. So technically, Your Honor, the instruction did track the statute, especially when you consider the parole portion of the statute. If Your Honors don't have any more questions about the penalty phase of Gregg's trial, I'll move on to the couple issues that opposing counsel raised regarding the guilt phase. First, in regard to Gregg's argument that the trial court prospectively denied all motions for continuance, I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference where the parties were discussing deadlines and how the case was scheduled in terms of proceeding forward, and the court just expressed his general dislike for continuing cases. But it's critical in this case that Gregg never moved for a continuance. She never sought more time. She never indicated that she needed more time to do anything. So there was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim and that there's no decision for this court even to review in regards to the, quote, prospective denial of motions for continuance. Turning to the Monotone issue, really Gregg argues form over substance here because the truth of the matter is that from the beginning of the pretrial hearings, the scheduling conferences, status conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief a thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court, and we would also refute her contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Gregg for both confidence to stand trial and monotone insanity. And as Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding and doing a monotone evaluation based on the fact that Gregg was on some drugs and that there was some medication history in regards to what she was prescribed. So after that, Gregg hired her own expert, which was Dr. Webb, to conduct her evaluation. She ended up not using Dr. Webb, hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation when the state's expert, Dr. Pickett, began his evaluation. And importantly for this point, again, is the fact that Gregg didn't object to any of this occurring. There was never a point in time where the trial court said he was going to appoint experts to conduct monotone evaluations, that Gregg said, no, we object to that, we don't want her evaluated, we're not going to plead insanity. Her only request at any time was that her expert evaluate her before the state's expert. But even when the state filed its formal written motion seeking to have her evaluated under monotone, Gregg did not object, and in fact, in the trial court, it asked, do you have any objection to the state's motion? And they said, no, Your Honor. So I think that any argument she makes that she should not have been evaluated under monotone before filing her 17.4B notice is really mooted by the fact that she herself acquiesced to being monotone evaluated even before filing that 17.4B notice.
I find this so interesting because the justices seem to be very, very hung up on the sentencing and what she got as a sentence. And the state said, now I'm paraphrasing because she spoke far more eloquently than I'm about to, but basically they said, bruh, we meant life without the possibility of parole, and life without the possibility of parole is what she got. They were not backing off of that. And I am very, very curious how that's going to play out.
Your Honors, if you don't have any further questions on any of the issues, then the state would rest on its brief and urge this court to affirm Gregg's convictions and sentences.
Any questions for Ms. Hartman? Thank you, counsel.
Thank you, Your Honors.
All right, Mr. Murphy.
How much time do I have? May it please the court. I'd like to address a couple quick points, if I may, before I move on to some more substantive argument. I believe it was Justice Sullivan who asked counsel whether the legislature could have, whether it's possible that the legislature intended for life in subsection 2B as it applies to juvenile first-degree murder, whether the legislature could have intended that that be life with parole irrespective of the parole statute, and counsel responded, possibly. I think that is very telling, in that I think at the very least, while we would assert that it very certainly does indicate that the legislature intended that, but we would assert that the state has now conceded at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, the brief that we cited, we included all of the canons of construction when the court is interpreting statutory construction, and one of those rules is the rules of leniency. And the leniency rule states that if there is a distinction to be made, if there is an ambiguous statute, and there are two interpretations, the interpretation that is most lenient to the defendant is the one that the court must adopt. And in this case, that adoption would be that the statute that was amended and in effect at the time of the sentencing is that Carly's sentence is life with the possibility of parole. I'd like to make that quick point. And also, Your Honor, I'd like to address, Your Honors, I'd like to address the state's reliance on Johnson v. State. 2 points I'd really like to make about that and why the state's reliance on that is misplaced. Number one, I believe it was Justice Coleman who pointed out that was decided well prior to the amendments to the statutes and in response possibly to Miller. But that case involved a very thorough Miller sentencing hearing. And that is distinguished from this case because there was no Miller sentencing hearing. There was, and again, I've used that term loosely, there was a sentencing hearing, but that was very, in effect, it was a sentencing argument. So in the case at bar, unlike in Johnson, we had no sentencing hearing, and I believe Miller not only stands for the proposition that there are certain factors that a jury or a trier of fact or whoever's deciding the sentence must consider. You can't just throw all these factors that the jury must consider at the wall and assume that they're going to consider them. So there's a substantive.
Jonah's mom, are you asserting that I cannot get away with saying bruh anymore? Is that what you're saying? Hey, Jen, it's a gypsy. Good to see you. Welcome in.
Aspect to Miller, but there's also a procedural aspect.
I'd also like to point out that when you further Google, can a minor tried as an adult and found guilty of first-degree murder be sentenced to life without parole in Mississippi, right? Okay, obviously, yes, all the things, right? Now, recent application. As a concrete example of this law being applied, a Rankin County, Mississippi jury found a 14-year-old girl guilty of first-degree murder after a trial in adult court, and a judge sentenced her to life without the possibility of parole. So I'm not exactly sure why the justices are arguing that she did not get that sentence when the state is saying, yes, she did. The defense is saying, yes, she did. And even the Googles is saying, yes, she did. That's all I wanted to say. That is all. Let's continue.
In other words, is the defendant given adequate process, adequate notice, and an adequate opportunity to address those Miller factors? And in this case, there was absolutely no notice that we're moving into the sentencing phase. I'm not even sure prior to the court turning to the state and saying, present your first sentencing witness, I'm not sure whether the litigants were even aware that that was going to happen. I certainly don't see anything in the record where the sentencing order or anything like that outlined that was going to happen. But certainly,
I think that the interpretation by everybody in that room, other than the justices, I'm sorry, justices, and I say this with all due respect, if it please the court, but everybody in that room is saying that that's what her sentence was. And that's what they meant. Because if there was a eligibility for parole, then that would have been included in the sentencing, i.e. eligible for parole consideration after 45 years, something to that effect. And there wasn't. Jonah's mom says, no, I'm saying that I have no business saying, bruh. Okay, just checking. Because hey, listen, sometimes I don't realize things. Sometimes I don't know if y'all have noticed that about me. And if I have no business saying bruh, tell me I have no business saying bruh, and I'll stop it immediately. Now, his argument is that he's not even sure that her defense attorneys were aware that they were going to go directly into the sentencing hearing, which I'm curious how that goes, because the way that I've seen it in trials is that the guilt or not guilt phase is presented, okay, and then the jury renders a verdict, and they, let's say, come back, like in this case, they say guilty. Then the sentencing or the punishment phase begins with the state presenting the aggravating factors and arguments for why, in this case, she should get life without the possibility of parole, while conversely, after the state has rested, then the defense gets to put their case of mitigating factors and mitigating circumstances on. And then There's a rebuttal case, and then it's handed to the jury, and the jury decides based on the evidence presented in the law and all the things that whether she'll get life without the possibility of parole or life with parole eligibility after X amount of years, whatever that is in the sentencing statute. And I do think that this is a very interesting question. Karen says, what kind of verdict did they want, and do they still want to achieve? This is what we need to ask ourselves. Okay. If the argument here is that no, she did not get life without the possibility of parole, that she actually will be, after some as yet indeterminate amount of time, she will be eligible. Eligible for parole only means that you get a parole hearing. It doesn't automatically mean that you're paroled. However, so let's say that happens, right? Let's say that she gets a parole hearing, right? What are we hoping to accomplish here? Are we trying to punish her? Or are we trying to rehabilitate her? Or are we trying to do some sort of combination of both? That is interesting to me. What about a pre-sentencing investigation? Wouldn't she receive that if no prior record? Let's look. Let me look it up, because it seems to be the argument made by the appellant is that she did not. So let's look. Did Carly Gregg get a pre-sentencing investigation? Let's see. There was no pre-sentencing. Hold on. Let me read this. Make sure I get it correct. The brief also argues that Craig did not receive a failed trial because of blah, blah, blah. He said that the defense didn't have a chance to call mitigation witnesses, and there was no pre-sentencing investigation before the sentence. So no, she didn't get one. It's kind of scary if what ends up happening is that this, after she's served her at let's just give it a round number, 45 years. All right. After 45 years, when she's 15 now. So, right. 15, almost 16. So she'll be what? 60 years old when she's eligible for parole, something like that. If they've gone this entire time and they put her in where they housed her based on the belief that she had life without the possibility of parole. And I'm curious about, due to the nature of the crime, does that make her ineligible to do certain things? Like we learned in Utah that Corey Richens getting a sentence of life without the possibility of parole makes her she will be in her cell for 23 hours a day, 7 days a week, 365. Okay. Do they do that in Mississippi? Because if that's the case, right, what happens then? What if she is eligible? What if they decide and they determine that she should be eligible for parole? And what if the parole board says that she's 55 years old, she has served her debt to society, and they go ahead and grant her parole, but she's not been eligible to do anything but sit in a cell for 23 hours a day? What kind of 60-year-old? What kind of 60-year-old are we releasing into society at that point? Because the argument that somebody who is of a certain age can't be a violent or cannot commit homicide is not true. Look at, what is her name? Is it Punta? That I'm thinking of, the little old lady that killed all those men and killed all those boarders for their Social Security checks. Let me look her up. Hold on.
The defense was not afforded any due process to address those Miller factors. And so we would move or posit that Johnson is really inapposite to Carly's case. Another issue that we would point out, and I'm just going to read from our brief, the state's reliance on Johnson v. State is misguided. According to the state, and I'm quoting from the state's brief, this court held in Johnson that the trial court's application of Section 4773 to sentence Johnson, who was 17 when he committed first-degree murder, to life imprisonment without the possibility of parole after a Miller hearing was not an abuse of discretion.
Dorothea Puente. That's who it was. I looked it up. Thanks, you guys. You guys got it. Thank you, Chicken Lady. Yeah, Dorothea. She operated in the 1980s, she ran a boarding house for the elderly and mentally disabled behind a grandmotherly facade. How old was she? Let me see. Let's look that up. How old was Dorothea Puente when she murdered victim? Oh, too many. 53 years old. She was 53 years old.
Thus, in harmony with Miller, Section 97.3.21.2b allowed Carly Gregg's jury to sentence her to life without parole, consistent with Section 47.7.3d, which is a parole statute, but only after it considered the Miller factors. However, the trial in Johnson occurred in 2000, as I think Justice Coleman and Justice Sullivan and perhaps a couple of other justices pointed that out. The trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97.3.21 from Senate Bill 2022 of our 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this in the initial argument, but I would like to address one of the errors that we have alleged that the defense did object to, and that was the introduction of the crime and punishment summation by Rebecca Kirk, who was one of Carly's counselors. During the state's rebuttal case, the state elicited testimony from Rebecca Kirk, who was, again, one of Carly's counselors, to summarize. Well, first she was asked what books Carly had read or was going to read, and there were several books that were mentioned. One of them was The Bell Jar, another was The Castle, and then there was Crime and Punishment. Curiously, the state did not ask Rebecca Kirk to summarize The Castle or The Bell Jar. The only one that they asked Rebecca Kirk to summarize was Crime and Punishment.
Coffee and Skeleton says, for some reason, I thought she was much older, but didn't she make herself look and act much older or something? Well, no, she did this for several years. By the time that she was caught, yes, she was very elderly. But when she began, she was 53. When she was caught, she was older. I'll tell you, I'll let him talk and then I'll look. Okay.
And this was over objection of defense counsel. And this was over objection of defense counsel after pointing out to the trial court that there's no proof that Carly even read the book at the time of the trial. Now, we would dispute whether or not that was ever established. I think in cross-examination, I think defense counsel got Ms. Kirk to admit that maybe she said she was going to read it, but she hadn't definitively read it or not. But whether she had read the book or not is really irrelevant. The plot of that book was a sensational plot that, as summarized by Rebecca Kirk, it was about a hatchet-wielding murderer who tried to assert the defense of insanity and then got away with it and was unremorseful and unrepentant. That was the summation of Rebecca Kirk. Now, not only would we assert that that was an incorrect recitation of the actual book, but at the very least, it was the important points that Rebecca Kirk remembered about the book. It was not the important points that perhaps Carly Gregg would have remembered about the book. But be that as it may, the only reason that the prosecution would want Rebecca Kirk to summarize that book is because the prosecution wanted that jury to hear those sordid details about that book and associate those details with Carly Gregg. They wanted the jury to think, well, if she read that book, she must have had those thoughts, and she must have hatched the plot to plead insanity after she read that book. That is exactly what the prosecution wanted the jury to believe, and that was over the objection of the defense. Now, I believe it was Justice King, and I believe Justice Coleman joined Justice King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing a affirmation of an appellate court. The Court of Appeals affirmed a finding of guilt after the prosecution was allowed to introduce rap lyrics. The Court of Appeals affirmed the conviction, and then the Supreme Court was split evenly 4-4. Again, I think Justice King filed an objection. Justice Coleman, I believe, joined in that objection. And there were several things that Justice King cited in his objection.
Better find it quick, buddy. You're at the you're under the
And I
2
believe
minute
that
warning.
court cited with approval a New Jersey case, State versus Skinner. In that holding, in State versus Skinner, the New Jersey Supreme Court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings and not tied by a strong nexus to the charged shooting in that case. Just as in this case, there is no nexus between what the writer of Crime and Punishment wrote and what was alleged that Carly did. There was no nexus. It was not even established that she had read the book. And I want to read a quote because I think it's extremely instructive from State versus Skinner. The difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. One would not presume that Bob Marley, who wrote the well-known song I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story, The Telltale Heart, simply because of their respective artistic endeavors on those subjects. The defendants, in that case, lyrics, should receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between the specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. And I would take that a step further. That case, and these cases that we cited in our brief, including Jordan v. State, Brooks v. State, United States v. Curtin, involved artistic works that the defendant was alleged to have written or participated in some form or fashion. In Carly's case, the artistic work at issue is a book that she had absolutely nothing to do with writing. She did not write that book. She had absolutely no contribution to the themes that were found in that book. So we would submit that the proposition cited by Justice King in Jordan v. State, by the Jersey Court and State v. Skinner, by the Ninth Circuit and United States v. Curtin are even more applicable in the case at bar than they were in those cases. And we would argue that the court erred in allowing the state to introduce that testimony.
Thank you, Mr. Murphy.
If there are no other questions by the justices, thank you, Your Honors.
Ms. Hartman, Mr. Murphy did not mention the crime and punishment argument during his initial presentation. Out of a sense of fairness, if you'd like an opportunity to respond to that, the court will give you a couple of minutes.
Thank you, Your Honor. Would.
Yes, what say you, madam?
Please, the court. So the majority of Gregg's argument for crime and punishment is essentially relevance, and that any relevance it did have was more prejudicial than probative. But that's not the standard. The standard is under 403 whether the probative value is substantially outweighed by the risk of unfair prejudice.
Well, Counselor, first you do have to answer the relevancy question.
Yes, Your Honor.
So there's no evidence that Ms. Gregg read that book, correct?
I would disagree with that, Your Honor.
She said she told the counselor she wanted to read the book.
And then she told her that she completed the reading.
Oh, she did say that?
Yes.
I'm sorry. Where is that in the record?
Let me see if I have that written exactly.
Yes, we'd like to see the receipts, please. I need the receipts.
I don't have that citation on my outline, but it is in our brief. I argue that point in the brief. So I know that I cited it there. And essentially, Rebecca Kirk and Gregg discussed those 3 books before spring break, and then they went on spring break, and then the appointment right after spring break, Gregg told Rebecca Kirk that she had completed the reading. So I think from that, it's a fair inference that she read the book.
So, and I'm sure you're correct. I'm sure that's in there. So assuming that it is, I still ask the question, what disputed fact in this case does that her reading of the report that she read that book make more or less likely to be true?
I think because the defense put on an insanity defense and they called Dr. Clark to the stand to testify that Gregg was criminally insane under Monotone. He testified that he relied on Rebecca Kirk's treatment notes, and then the state called Rebecca Kirk to rebut Gregg's insanity defense and rebut Clark's testimony about her Monotone insanity. So it's our contention that that's relevant. Her state of mind, the materials she was ingesting, the discussions she was having with her therapist, even about these difficult and complicated classic books, bore on Rebecca Kirk's testimony about her treatment of Carly Gregg, even just 24 hours before Gregg went and murdered her mom. So I think that Rebecca Kirk's treatment notes, including that reference, are relevant to the state's rebuttal of her insanity defense. And Your Honors, even if this court is inclined to hold that Rebecca Kirk should not have been permitted to testify about the summary of crime and punishment, I think this is a classic example of harmless error because Gregg was not convicted because Rebecca Kirk summarized crime and punishment on the stand. She was convicted because the state presented extensive and overwhelming evidence that she was sane at the time when she murdered her mom and that she committed the murder with deliberate design. Just a few examples. She appreciated where the security cameras were in the kitchen. She hid the gun behind her back when she was in view of the security cameras so that the camera wouldn't see it. She covered her mom's face with a towel after she shot her point blank in the face 3 times. She called multiple friends on the phone and said things like, "I messed up, don't call the police," things that would indicate that she knew what she had done was wrong. She even took her mom's cell phone off the counter right after she murdered her, put in the correct passcode, and then went in the phone, found Heath's contact information, and texted him and asked when he would be home, acting like Ashley. This and abundance of other examples prove that Gregg murdered her mom with deliberate design, but more importantly, that she understood the difference between right and wrong when she murdered her mom, so she was sane under Monotone. So irrespective of the crime and punishment summary, Gregg would have been convicted, and this court should affirm her convictions and sentences. Thank you, Your Honors.
Thank you, counsel. The court appreciates your arguments and will take this matter under advisement and render decision in due course. We stand adjourned.
Okay. First of all, let me tell you guys what song has been stuck in my head for the last 3 days. Oh, I was listening, making sure that my stream was going good. It is, well, I'm Easy E. I got bitches galore. You might have a lot of bitches, but I got much more. Easy does it. All right, now, Gypsy. There's a kerfuffle. There's some shenanigans afoot. Allegedly, Nina the beauty influencer was sent a video from a person who wishes to remain anonymous. She said she cannot show this video because if she shows this video, it will reveal the source. But allegedly, and according to Nina, on that video, Gypsy like puts an X over Ken and makes stabbing motions similar. It is a video that is very similar in nature, allegedly, to the video she sent to Nicholas Godejohn instructing him how to murder her mother. That is the allegation. There's another allegation that her ex-husband Ryan is talking to, seeing something, some type of romantic there's some type of romantic inclination, nature, something going on between Ryan Anderson and one of Ken's sisters. Now, to that I say this. To that I say this. If it's true, it's deeply concerning. But I got to say, not surprising. And why is it not surprising? And why should Ken not be shocked? Because he knew about all this stuff before he got with her. So now, and he made the decision to get with her the first time, and then to get with her again. Okay, and do activities that can only that can result in making a child. Okay, there are ways to prevent pregnancy. Both parties can take separate measures to prevent that. So am I shocked that this is an oh yes, Kimberly, cruising down the street in my 6'4", jocking the bitches, slapping the hoes, went to the park to get the scoop, knuckleheads out there shooting some hoop. A car rolls up, who can it be? A fresh El Camino rolling kilo G. I love NWA and Eazy-E. I remember when Straight Outta Compton came on MTV for the first time, and I was young. Okay, I sat there with my jaw on the floor, and I ate up every beat, every rhyme, every lyric, everything. I was enthralled. Now the whole song is in my head, but bottom line is with Ken and Gypsy and whatever. Okay. At the end of the day, okay, Ken knew what he was getting into. Now, does that mean that he should stick around now that he knew what she was capable of? If that exists, it's now on Ken what he does next. Not, good luck to everybody in that situation, but mostly good luck to the baby who's involved, who's the innocent in all of this. I was going to tell you, should we, you guys? I mean, there isn't any trial that I'm like super interested in covering, like a live one. right, that's going on right now, but I wouldn't mind going over the Carly Craig interview or trial. And what we can do is, so what's today? Today is Wednesday. We can do Carly Craig, and I can do because I don't have the Nuggie this weekend, so I can do Drummond this weekend if you guys want. Would you be amenable to that? Would you acquiesce to that? Bye, coffee. See ya. Good luck at your good luck at your appointment. I'm laughing at Jenny, who says, in the words of Sarah Boone, that's on you. That's on you. Oh, Boone. I'm curious what's going to happen with her trial, her appeal, I should say. If she'll get, I don't think she's going to be successful, but we'll see. We shall see. So that's kind of all I had for you guys. But yeah, if you are, let me know if you guys are interested, because it's not one that we covered, but it is one that I wanted to. I'm just trying to remember what it's over. The court was adjourned. They got to think about it, and they'll be back. The state Supreme Court, you file the brief, then they will decide if they're going to hear arguments, right? And then they hear the arguments, and then they say, okay, well, then we'll make our decision. And they make their decision whenever the hell they get around to making their decision. Because to be fair to them, this is like, they got to go through the brief that was filed, both the initial brief that's filed by the appellant, and then they go through the state's response. But they also have a voluminous amount of trial transcripts, which they seem to have gone through a little bit already. They kind of they know what the deal was with the trial, but then they also have to look at all of the citations in that both respective briefs, and then read those, right, and determine if the state's interpretation of the citation is correct, or if the defense's, or I should say the appellate's interpretation of that statute, Letitia, is correct. So there you go. Oh, did you? Jonah's mom said you will appreciate this, Bendy. I was mad the other night, so I had to watch something that would make me happy. So I watched the original trilogy of Star Wars, episodes 4, 5, and 6. Oh my gosh, y'all. I almost forgot. Speaking of, this is more than a trilogy, though, at this point. Do y'all know that tomorrow on Paramount Plus is the premiere of Scream 7? Oh, I did not even know that there was an in-chamber hearing of Donna Adelson. Now, how would I be able to cover that? Let me see what's going on with her. Let's see. Let's see. Give me just 1 second. The Nuggie is right here and she needs something. Hold on. All right, so let's see what's going on for ongoing coverage. Let's see. I don't see anything coming up, but I am thinking if it's in chambers, how would I be able to cover that? However, let me just say this. I can't believe I didn't even know there was an update. I feel so dumb and out of the loop and like I'm not even doing my job. What has my life become? All right, so this is what I'll do. I will look into this. Jenny says it was open, then sealed up. Leslie B has the document. It has a few good things. I will look into it. And I likely will cover it because, Jenny, would you do me a big, huge favor? Can you email me and let me know where I can find that? And that way I can go over it. Of course, if I use another creator's document, anything, you know, I always give credit. So know that first. Because I am quite interested in what's going on with Donna Adelson. I'm also quite interested in seeing if Wendy ever gets charged with anything. I'm curious about that. Will they ever charge her? Let's see. Yeah. So, does he? Okay, I'll go look at Mentor Lawyer. I'll look there. I do like Mentor Lawyer. All right, you guys, I'm going to let you go for now. I think what we'll do then tomorrow is we'll go ahead and look at Carly Gregg. I think that's like a good thing to do. Let's go see, these are the basis for the appeals, right? And let's see what happened in that case. All right. All right. Thank you guys so very much for being here. I appreciate it very, very much. If you have not done so already, would you please give your girl thumbs up, thumbs down? I leave it to your good judgment, whichever you feel that I have earned. And I will see you guys tomorrow morning, say 9 o'clock Central, 10 Eastern, 7 Pacific, 8 Mountain. Sound good? All right, that's what we'll do. I'm curious about this, Jenny. I will look into it. All right, you guys, and whatever I find, I'll update you guys with on this weekend or tomorrow, whenever I find it. But I also want to say this. I'll just use this weekend to catch up on all of the things that I haven't caught up on with court. I feel like we must, like it's a requirement for us to watch the sentencing hearing of Suzanne Miracle, because it was full of BS. And we watched her entire BS trial, so we might as well watch the sentencing too. And but we're gonna put it at least 1.25 speed. But I definitely wanna see it. Thank you, Jenny. I appreciate that very much. All right, you guys, I will talk to you guys tomorrow. I'll see you tomorrow. We'll cover Carly Gregg. And y'all have a great rest of your afternoon, and I'll talk to y'all later. All right, bye.